on the fact that the court dismissed the petition. Yes, it is true that court dismissed the petition in favor of the county government, but it is not a correct proposition that when court dismisses a matter with costs, the costs are meant to cover the legal costs for the advocate. That is not the correct position. Ideally, these costs belong to the client. So the advocate on record ought to have assessed these costs and the money paid to the county government, not advocate's fees. Now the advocate's fees paid, if you look at it keenly, it strictly complies with the provisions of the advocate's remuneration order. There was no extra charge paid in respect to that fees towards the advocate. The third issue on pending bills, it is correct that we still have outstanding payments for pending bills, but I must also report that out of the budgetary allocation given to the department, we have substantially covered the amount of pending bills. If given an opportunity, we should be able to submit a report which indicates what we have covered so far and what remains to be covered. That's all, Chair. Number one, the law will tell you that for any disposition touching on land, there must be a written agreement with respect to that transaction. There was absolutely no agreement between the local authority and either the father or any family member. Number two, the documents that ideally ought to have been held by the Registrar of Lands, and I say this with authority because the judge directed the Registrar of Lands Bondo to appear before court. And there was absolutely no document in the records in Bondo to demonstrate how this land moved from this person to the county government. Now, in the presence of that glaring anomaly, you cannot commit the county government to continue pursuing this interest when you know for a fact you are fighting a losing battle. Remember that in court, we don't go to court to argue the way I'm talking like this. In court, you go with evidence. In the absence of evidence, there is absolutely nothing you tell in court. So for those reasons, we had no reason to continue pursuing that matter, which is why when the former county attorney did an opinion to the cabinet about this position, the cabinet was persuaded to approve negotiations out of court. And before even cabinet was persuaded, the judge was so lenient to us and even advised, could you kindly try to explore this matter out of court, because it is constitutionally permitted. Now, if we insisted that we want to continue doing the hearing to its logical conclusion, we were honestly being unfair to the county government. The fact that you hold a title deed does not give you security over any parcel of land. You must demonstrate, if a dispute is raised over your holding of that title deed, that you acquired that title deed legally, regularly, and properly. In the absence of that, you have no basis continuing flashing that title deed as a document of ownership. By the time this matter was going to court, the investment in terms of the value of the project that was already on the land was at 22 million. That is outside the value of the land itself. Now, the risk we suffered is this. If you look at the orders these people are asking for, the first order was asking that we are evicted from that parcel. If the order of eviction is granted, you can already see you are losing 22 million plus the value of the land, which if we were to go by the joint valuation report, the value of the land alone stood at 23 million. So already you can see you stood to lose 45 million before you start. But in the event that the order of eviction was not given and the court ordered that we compensate them monetarily, they were asking to be given 28 million plus 10 million general damages plus 5 million what we call mesne profits for arising out of trespass. By my own calculation, that brings that thing to about 43 million. So the payment of 26 million, if you do a simple arithmetic calculation, 43 or 45 minus 26, you can clearly see we've saved well slightly over 15 million, plus costs of the suit. We have no record to indicate whether it was a purchase, a donation, or whatever. And I agree with you that at this particular point, perhaps what we may need to do is to involve the investigative agencies to help us determine some of these things from them, because you and I were not there when the transaction was taking place.
Following a joint valuation exercise by valuers from both parties, the suit property was valued at KSH.26. See valuation reports and certificate of joint valuation as attached in Annex 7. Further, the Cabinet approved settlement of the claim for a total of KSH.26 million. Number 2, the firm of Orengo and Company Advocates offered legal service to the county government of Siaya and was paid a fee of KSH.4.06 million in strict compliance with the Advocates Remuneration Order. The fee not provided by the law firm is descriptive of the nature of services rendered as well as the fees charged for the service. At the time of the audit, we provided the auditor with the fee note as well as the judgment of court which equally indicates that the advocate was on record for the county government. See attached copy of court judgment. The pending bills arising from court awards and fee notes has largely been occasioned by sufficient budget allocation in the current financial year. We have a budget allocation of 22.6. The amount will be topped up with the supplementary budget for 24-25. Valuation report from SE Appraisal, Annex 7, valuation report from SE Appraisal Limited, 26.5, valuation report from the county government, 20, certificate of joint valuation, 23, fee note copy of court judgment, and a fee note copy of court judgment. Now, Chair, maybe this is meeting late, but it's part of the document that we provided earlier. There is court exam, the additional information that we provided earlier.
You know, I believe that in 1990, there were people in those offices who did these transactions, right? And I believe that they are still alive. So when I say, and when I ask you, if you engage the investigative agencies, I believe that the title is a government property, right? And it's important that we establish how it came to the hands of the county government or the defunct local authority. Have we done that? I believe that the document in question is a government document, and that there is a way it was obtained. There is a procedure of getting a title deed. How did we get this title deed? This is what we should be investigating. Perhaps we had paid for this thing. Perhaps the previous office holders have some information about this, right? Why did we involve them?
That the land was indigenously owned by an individual, and then it was, through some process, it was transferred to the county government, and thereof, the county government attained a title deed. And in the process, the county government went ahead, knowing that they have the full ownership of the land, and started erecting a bus park. And then eventually, they were intercepted by the owners, now the sons of the person who, through that process that was done previously, transferred the land. In this regard, what is the county government doing? Because as we speak, there are several markets, the same several markets. And you know, initially, it's like the county governments, or rather the local authorities, did not have enough land. And in that regard, they were making some arrangements, either through some payments and etc., with the people around those markets to help expand. And this was done in a manner like the one you were trying to explain. That was an old museum. They talk to the old museum through some process. The old museum agrees. Then land is transferred. Title deed is what is processed. So up to this extent, don't you know that like all the markets and most of the land that is owned by the county government will suffer the same? Because if this is just one of them, then it is evident that in the subsequent markets, whether you will be developing there or you will not be developing, then there is an underlying issue that is similar to this one. And to that extent, how are you advising? Because we do not want a repeat of the same, because losing over 26 million is not a small amount of money.
Waziri, don't take us back to Senate. You must clean our house before you go to Senate. And this is a question from the auditor that will take you to Senate. And if you cannot address it now, the Senate cannot address it for you. One, when was this land bought by the defunct local authority? And what was the value at that particular time? And if they bought it, do you have any title for the same? Two, you say the value at that particular time when the issues were being raised, the value was 22 million. And your rate of negotiation was 26 million. So how, after improving your land up to a value of 22 million, at the time of purchase, how much was the value? And how do you agree to pay 26 without negotiating for 26, without even budgeting, without even knowing where the money is coming from, and you are defending it? Can you explain? The investigative officers, you didn't involve with us. You didn't involve with us. And how did you decide to pay 26 million? Just because somebody has claimed, you agree and you pay? What was the payment? And how did you go to court? You could even ask court, give us time, we involve the ESCC or the whichever body to investigate and give you a proper answer before even allowing to pay 26 million. Or somebody has a percent that was really convincing the other parties to look, to pay out 26 million. Should be having records. ESCC are doing the same for other countries. You mean they could not do the same thing for Siaya County before we part with 26 million? And how did you convince the court that we agree without having any backing document? And how did you come out of court settlement? And Waziri, how did you pay 26 million? Somebody advocate comes to you, you pay 26 million. Just because the advocate has said, the court has said. And you say it is out of court settlement. What percentage were these other people getting out of this? Without involving the investigating officers to do the job, the ESCC to do it. And we are missing medicines from our hospitals just because someone said pay 26 million. This is unacceptable.
Then the process of processing the UPN must also take place. So we may have that at any given time there could be one or two or a few employees whose UPN numbers are not yet in place, but it is including for casual workers.
Unlimited gratuity, which was saying does not relate well with the gross pay of 14,519,000. Could that be right?
Which is not related at all to gratuity, baggage allowance, and even the codes that are listed here. So I think even if it was, he's saying it is an error, but this is the document we made right.
Further, there is no error in that document. I did not say there is an error in that document. I said sometimes we may omit to process gratuity for certain rules.
But there's something that they never highlighted, or rather that the department never highlighted in some of the writings, but he's not trying to explain. How do you come here to explain to us what is just in your mind, and yet we wanted these things for our...
We process it as a byproduct, support of accompanying the payrolls for each and every month.
Is it a constant figure?
It varies depending on the gross basic pay of
component of the gratuity or the pensions, and then we do that reconciliation. So through the system, we are able to detect an individual that must be paid or bill must be paid. 395, that line 237, 238, 239, and 240. And then you're able to, if you go to column 3, column 4, column 5, you're able to see column 5, it says baggage allowance and related gratuity, schedule of grant as per program-based budget, extract, inaccuracies in bank balances, and supported acquisition of assets,